Our first guest of the program is West Virginia Intermediate Court of Appeals Judge Dan Greear. He joins us via telephone. Judge, good morning. Thank you so much for being with us.
Well, thank you for having me. It's a pleasure, and I love Band of Brothers. That's an awesome series. But good morning to you guys.
Yes, that's something. Did you by chance catch Masters of the Air a couple years ago on the Apple? That was a mini series, kind of similar.
I did not. I don't get Apple. I get enough of those streaming services. That's not one that I've gotten, but I would love to see that. I haven't had the opportunity.
Yeah, it's kind of a similar setup and everything based on true story and real people who went through it. It's just these guys were the ones that were flying the planes and doing the air-to-air battles and dropping bombs.
Yeah, the graphics in Master of the Skies were unbelievable. I don't know about Band of Brothers, but the video graphics was superb.
Very intense, very intense. Judge, of all the things on your resume that caught my eye, being a football referee was the first one that jumped out. Tell me about this a little bit, too.
Sure. I just finished my 25th year last fall. You get a nice gaudy ring when you hit 25 years. So I have my 25-year ring as a football official. Had several friends that were in it. I played football in high school and sort of got away from the sport for a while. But when I was about 30, several of my friends encouraged me to do that, and I've been doing it for the last 25 years. And it is just a great way to get away from work or whatever is going on, and for the 4 or 5 hours on a Friday night when you're traveling with your crew and going to a high school somewhere and calling a football game, it just sort of takes your mind off of everything else and a sort of a way to relax and just have good friends with you there. But it's been a wonderful experience. It's as far as a hobby goes, it's the best thing I've ever done. And I don't know that you make a whole lot of money, but at least you break even, which is better than you do playing golf. So it's a pretty good deal.
So would any of the football coaches, and I've been on many a high school football sideline, would any of the football coaches actually give you a little deference on a call they disagreed with because you're a judge?
Absolutely not. That has never once occurred. I've often pondered whether I could threaten to hold them in contempt of court, but I've never tried that yet. But no, I don't think anybody's ever cut me any slack because I was a judge.
Have you ever seen any of the folks you see on Friday night later on in your courtroom?
No, I have not. I have not. I haven't experienced that, so that's probably best for all of us.
Oh, that's probably a good thing, I guess. Tell me about your time as a member of the ICA and how you wound up there, and if that was one of your goals at the time when you wound up there. It was created by the legislature in 2021. There had been a lot of discussion about the ICA for a number of years. Interestingly enough, the legislature was given the authority to create an intermediate court way back in 1974 in the Judicial Reorganization Amendment when that was passed. So that had been sitting there for a long time, and nothing had ever happened with it. Over the years, there came some controversies with the Supreme Court in the early 2000s. There were several multi-million-dollar verdicts that were appealed, or a couple of multi-million-dollar verdicts that were appealed to the Supreme Court. And back then, the review was discretionary, and the Supreme Court just refused to hear those cases. And there was a lot of controversy about that. Governor Manchin at the time formed a commission that was chaired by Sandra Day O'Connor, who had retired from the Supreme Court. One of their recommendations of that commission that looked at the judicial system was a creation of an intermediate court. And that kind of gained some momentum down through the years, and after several years of sort of going through the legislative process, it was finally passed, and Governor Justice got to appoint the initial three of judges. That was myself, Tom Scar, and Charlie Lawrenson, who may or may not be the brother-in-law of Maria there.
I was gonna go there, Dan, and give you some full disclosure here, but you stole my thunder. It's fine.
I was aware of that, but that's my burden to have to be on the court with Charlie. But that's a joke. He's a wonderful colleague. But yeah, when it was created, that
was certainly a goal of mine to be a part of that court, and I was fortunate enough to be appointed initially along with Charlie and Tom Scar. And in the coming up on 3 years that we've been in existence, we've had about 1,600 cases filed with us, and we've disposed of about 1,300 of them in rough figures. So, quite frankly, I think we've done a pretty good job of going from scratch to being an active court, and in terms of disposing of cases and hearing cases and keeping the ball rolling and aware of what our role is as an intermediate court. So, I think we've been fairly successful in getting the ball rolling the way the legislature intended, and quite frankly, it's been the favorite job that I've ever had. I've always heard the old saying that if you have a job you love, you never work again a day in your life, and I don't know that I ever experienced that fully until this current job. But I absolutely love what I'm doing, and I love the people that I get to do it with. So I've had a great opportunity here, and I look forward to running and hopefully having another 10 years in his position after the election next May.
Yeah, you have officially announced your intention to return to the seat, and you said that is a 10-year post?
Yeah, yes. Upon election, it's for a 10-year term. On the initial appointments, we were given staggered appointments. Judge Scar got a 2-year appointment. I got a 4-year appointment, and Charlie Lawrenson got the 6th-year. Judge Scar didn't run for re-election, and Ryan White now sits in his seat. But after the election in May, that will be for a 10-year term.
Bill?
Yeah, good morning, Judge. Thanks for joining us on this rainy day. We've all heard about the ICA, but we don't really understand a lot about it. Would you give us a basic tutorial of what you do and the various types of cases that you review?
Absolutely, we'd be happy to. As the name implies, we're an intermediate level of review of cases decided below. We have 4 main areas of jurisdiction. We don't receive everything. We don't have unlimited jurisdiction like the Supreme Court that hears everything. Our 4 main areas of review are general civil cases, just civil lawsuits. And that makes up about 32% of our docket. Family law appeals from family courts throughout the state, that makes up about 25% of our docket. Workers' compensation appeals. When we were created, prior to the time we were created, the workers' comp decisions that were first made by a claims administrator, then went to the Office of Judges, then to the Board of Review, and then the Supreme Court. With the creation of our court, they eliminated the Office of Judges. So now in the workers' comp system, a claims administrator makes a decision. That can be appealed to the Board of Review, and from there it comes to us. And the comp makes up about 30% of our work. And then finally, we get administrative law appeals. For example, when somebody, you've heard a lot in the legislature about certificate of need and whether we should continue that or not. But when those applications are made, if they're denied or they're granted, an affected party can appeal to us, and we can review that decision. Or if the DEP, issues some kind of environmental fine, to a company, for instance, the parties to that can appeal that decision to us. So administrative law appeals make up about 12% of our jurisdiction. We do not get criminal appeals. We do not get any abuse and neglect appeals. Those all go straight to the Supreme Court. But any of those 4 categories of cases that we hear, civil, family law, compensation, administrative law, all of those after we render a decision, we don't take trials. We don't hear new evidence. We render a decision based on the record below, the evidence that was presented below, and the arguments that lawyers make. And after we render a decision, all the parties have a right to appeal our decisions to the Supreme Court. And just as a statistical fact, since we've been in existence, we've disposed of about 1,300 cases. 258 of those have been appealed from us to the Supreme Court. So around 20% of our decisions have been appealed to the Supreme Court. About 80%, once we render a decision, the parties are satisfied enough, at least, that they don't decide to take another appeal. So about 80% of our cases, that ends the case right there. So that may be more information than you needed, but I hope that helps.
It helped very much. That was a very good synopsis of what you do. One of the reasons for establishing the ICA was to take some of the workload off the Supreme Court and to reduce some of the backlog. I assume there are some numbers that will support your success in doing just that. Is that correct?
I think so. I think that's going to be borne out. But let me talk about something else related to that, because I think it's even more important. I think even more important than reducing the workload for the Supreme Court is that we've reduced the workload for the circuit courts. And how that works, the family law cases that we get and the administrative law cases that we get, prior to our court, those went to the circuit court. So whenever a family law judge in West Virginia would make a decision before our court, that would be appealed to a circuit judge. And that created a couple problems, quite frankly. Number one, you all know that circuit judges, and Maria could testify to this too, but circuit judges, one thing they don't have a lot of is extra time. And their dockets are absolutely jammed with, abuse and neglect cases, drug cases. They don't need extra cases on their docket. And so 37% of our docket, the family law cases and the administrative law cases, are cases that the circuit judges don't have to deal with anymore. And I think that's probably, as far as workload management, that's probably even more important than the cases we've taken off of the Supreme Court. But we do have an effect on the Supreme Court as well. As I mentioned, like the civil cases that used to all go to the Supreme Court, well, now 80% of those are done after we render our decision, so they're only getting a fifth of the number of civil cases that they used to get. So that's undoubtedly going to increase their overall workload over time and allow them to get to criminal cases, abuse and neglect cases at a faster rate.
Yeah, let me squeeze one more question in before Maria starts her cross-examination.
That's fair.
Okay.
I might get a question. Just saying.
Understand you're going to have at least one session in Berkeley, Jefferson County this fall, and would you describe that, please, Judge?
Yeah, absolutely. We're coming to visit Shepherd on September 16th. One of the things that I started, I had the privilege to be the first chief judge in a program I initiated, and the other chief judges have followed since. Is we go to one of our higher education institutions each term, once a spring and once a fall, and actually hear cases on the college campus. The Supreme Court in the past has gone to the WVU College of Law and to Marshall University to hear cases, and they also have gone to high schools. But one of the things we noticed is that nobody was going around to colleges such as Shepherd or Fairmont State or Concord or whatever. So we've initiated that program, and on September 16th we'll actually be hearing cases up there at Shepherd. The public's invited, the students are invited. Local high schools will come out to that, but primarily we think that's a great opportunity for students at Shepherd who may be interested in going to law school or being in government or that kind of thing to see the judicial system at work. Certainly in the Panhandle there, believe me, I know how far that is from Charleston, and it gives the people of the Eastern Panhandle a chance to see their government at work and see a branch at least above the circuit court level that they don't get to see a whole lot. But we're going to be there in Shepherd and actually hear a handful of cases, and people can come out and see exactly how the process works. So we're really looking forward to being up there.
Maria.
So, Judge, just as a matter of course then, so when this court travels, it is for specific instances such as this. If you're going to Shepherd or to Concord, like you mentioned, but you normally sit in Charleston, or do you are you a moving court, so to speak?
We sat in Charleston, except for these special occasions. But there is one caveat to that. As part of our creation, we established 5 what we call remote courtrooms, and those are located. The closest one to Morgan County in the Panhandle is one of them. In addition to Morgan County, we have Hardy, Lewis, Wetzel, and Raleigh. And if you sort of think geographically about where those are at, the idea was to place those 5 satellite courtrooms in a location where no one had to drive more than an hour or so, hour and a half at most, to get to one of those. So litigants
in the Eastern Panhandle, for example, if there's a case from Jefferson County, instead of hauling the 5 hours to Charleston and having to spend the night and get a hotel and all those kinds of things, the lawyers and the parties can travel down to Morgan County and a lot less time, a lot less expense, and we have the video system set up and the equipment in our courtroom that the attorneys and the parties can be there and argue the case just like they were there in person. And about 20% of our arguments that we've had have utilized that kind of technology. So, it certainly saves time and expense for people in the Panhandle, for example, coming down to Charleston, and we think that's been a very effective way to give convenience to people. So that even though we're not traveling around, we sort of bring the court to them in that respect.
And these are sitting courthouses that you go to. For example, in Morgan County, it is the Morgan County Courthouse where the circuit court normally sits. Yes,
that's exactly right. In each of those 5 locations I mentioned in the county courthouse, we have our own room, dedicated that's solely our courtroom, our satellite courtroom. It's not used for anything else, and we arrange with either the sheriffs of that county or the state police, and we'll have law enforcement officers there every time it's being utilized. But it is a dedicated location at those county courthouses. Absolutely.
So, Judge, talk a little bit about this. Is a little bit of a change in the question tenor here. We have heard from some of our local officials that there is a mindset to add a political party to the judicial races. And of course, judicial races used to be political, used to have a D or an R after the person who's running, but now they are not. Would you favor personally the return to that? The argument, of course, being sometimes you don't know a circuit judge, an appeals court judge, and the D or the R helps to give you a sense of where they fall on the political spectrum.
I'm gonna be up front, and I'm gonna dodge the question a little bit, but I'm happy to address it. You're correct that there has been a push recently to go back to partisan election of judges from nonpartisan. Ironically, I've been involved in elections that work both ways, and there's pros and cons about each system. In the position that I'm in, as a candidate next May, the way I'm approaching that is, the legislature gets to make the rules, and whatever rules they come up with, I'll be happy to participate however they want me to. One thing I will say anecdotally, and in terms of the party of judicial candidates, and I'm a lifelong Republican. I'll throw that out there. I served as a delegate back in the 90s as a Republican, so I don't hide that. I'm happy to tell people that's what I am. But when you're out going door to door, or when you're talking to people at parades or whatever, absolutely the most common question I get as a judicial candidate is, "What party are you?" And oftentimes the response is, "Well, that's a nonpartisan election. You don't have a party by your name," and you're usually interrupted, and people say, "I don't care whether it's nonpartisan or not. What party are you?" So I can tell you the citizens certainly are interested in that information, because whether that's good or bad, it's not even close. The number one question that I get asked as a judicial candidate before anything else is, "What party are you?" So that's certainly information that voters want. But in terms of my personal preference, running for re-election, I just want the legislature to tell me what the rules are, and I'll follow them, whatever that is.
Similar in nature to that is the timing of the elections. From a perspective of a person who's practiced law, is it better to have this election in May or November?
Certainly there's some advantages, and the argument there has usually been, as I've heard it, if the election is in November and somebody has an active practice of law, that doesn't give them a whole lot of time to wrap it up and to transition into office by January or so, and so it helps more in May.
And there's some truth to that, certainly. I don't know that that's dispositive. I don't know that that's as big a deal one way or another. I certainly think there's some obstacles that could be overcome if it were to be moved to November, but I don't think that's as big a concern, quite frankly, as whether the policy preference is partisan or nonpartisan. I think that's more important than how much time you have to transition, because I mean it's certainly an advantage to have more time, and I'm certain it makes it easier and more convenient for a lawyer that's going to transition into the judicial office. But that's certainly something that could be overcome. I don't think that should be a dispositive issue one way or the other.
Final couple minutes here with Intermediate Court of Appeals Judge Dan Greear, who's running for re-election. Bill?
Yeah, picking up on this partisan, nonpartisan, we have the same thing or similar with the closed primary and the open primary. My gut sense is that both of these issues would serve as an advantage if the parties were evenly divided, or closely evenly divided. But in this case, the Republicans dominate by huge numbers. So I'm a little surprised in both the open primary and also the partisan, nonpartisan issue arising at this point in time. I thought it'd be just the opposite.
Yeah, I understand that. It's kind of interesting how the who that advantages and which party stands to benefit by those rules has kind of switched over the years, and sort of interesting to watch different sides take different positions on those issues as the political fortunes have changed in the state. But it's an interesting debate to follow. Again, as in the judiciary, as judges, we try not to get involved in those policy debates. I think the role of judges isn't to decide those kind of issues ourselves, but to be deferential to the legislature. That's really a key for a good judge, in my opinion, is to understand the role and be deferential to the legislature. And those are all interesting policy questions, but my point of view is that's up to the legislature to decide, and we'll apply the rules however that comes out.
Judge, thanks so much for your time this morning. We have about 30 seconds left. If there's anything else you'd like to relay, please do it now.
Well, I just want to thank you all for having me on and having the opportunity to talk to you folks. And, again, we look forward to being up there in September, and I'd invite everybody out on the 16th of September to Shepherd University and come see us in person. I'd love to meet people from the Panhandle.
Thank you, Judge. I always enjoy talking to a high school football referee.
Thanks, Judge.
Right, take care.
Thanks, Judge.
Bye-bye.
Sounds like a wonderful guy. I just hope I never have to see him in a courtroom. Right?